Okay, well, good afternoon, everyone. My name is Brian Sloan. I'm the chair of the Cambridge Socio-Legal Group, and I'm also a member of Cambridge Family Law. I'm absolutely delighted that William is here to talk to us this afternoon. He is hugely experienced in Jewish law, but he's also a current Cambridge undergraduate, and I had the pleasure of supervising him in family law last year. I think he's the first ever student to tell me that his essay might be a little bit delayed because he was dealing with reviewer comments for a peer-reviewed journal, but he did extremely well in the end, and he's also published a paper on the topic of this seminar in the Child and Family Law Quarterly. Just as a matter of housekeeping, at the end of his presentation, William is very happy to take questions. There are going to be two methods of asking a question, one of which is simply to type your question into the Q&A. Another is to raise your hand, and following that, I will unmute you and you can ask your question orally. But we'll recap that when we get to the end. So without any further ado, I'd like to invite William to begin his presentation on can the consent required for religious divorce be secured by state coercion. Thank you very much.
Thank you very much for that, Brian. I just want to check that everyone can see what I can see, which is my slides. Or at least, Brian, can you? Is that all right?
Yes, I can, certainly. Yeah.
Okay, excellent. Seeing as just looking at the participants today, we have a great variety. I'm not sure we've ever managed to bring together people from the academic family law community, legislators, and rabbinic authorities. I'm not going to assume any knowledge from anyone, so I am going to start from the basics of Jewish divorce law, discuss what the issue is currently in the United Kingdom, discuss the things that are being done about it, and then discuss how those solutions might be made more effective when done in collaboration with Jewish law authorities and in understanding of the basic principles of Jewish law which govern the area. So to start off, I'm just going to run through the basics of Jewish divorce law. So the basics of Jewish divorce law, the source is the verses in Deuteronomy, which I've put up on the slide. This is just a rough translation of mine. A man takes a woman, she displeases him. He shall write her a book of severance and place it in her hand, and that allows her to go and become another man's wife. And on the slide here, we have a picture of this book of severance actually looks like. It's called a get in the Jewish legal sources, based on the Aramaic. And essentially, this is just on the side a get from 1822, but the get has looked the same for centuries and still looks the same today. It's a form of legal document which the husband then places in the wife's hand, and that renders the wife divorced under Jewish law. Now, obviously, I'm not going to run through all the rules, but what's really relevant for our purposes are two rules which are somewhat consequent on each other. So there's a requirement of consent. And initially, Jewish law only required that the husband consent. And as you can see that in the source, a husband can only be divorced by his own will. Now, what does the consent requirement mean in relation to the husband? Clearly, in one sense, a husband's consent is always present because the divorce is affected by an act done by the husband. He places the get into the woman's hand. But the Talmud is clear that's not sufficient. If the husband grants the get knowingly, but only does so under duress, then the get is invalid. And that is the next quote from Gittin on the slide. Now, to be clear, let's just to make the comparative point. Unlike in English law, duress operates by vitiating consent. So it renders a divorce procured by duress void. It's not merely voidable, it's void ab initio because there's no consent because it was coerced. So therefore, such a get is simply void, unlike similar provisions in English law, in contract law, in marriage law, etc. Now, later on, this is the Talmud, which is where we will find majority the sources of Jewish law following the Bible, and it's compiled. The Mishnah is compiled around 200, and then the Talmud is later compiled in Babylonia in a few centuries later. And at that point, only the consent of the husband was required. An enactment of Rabbeinu Gershom, who's a very early German Jewish authority who dies around the turn of the first millennium, required mutual consent so the wife has to consent to the divorce as well. And this is binding on Ashkenazi Jews, who form the vast majority of Jews in the United Kingdom. Now, strictly speaking, and leaving some minority opinions aside, the grant of a divorce in Jewish law is a private law act between a husband and wife. So unlike English law, it's not a judicial act, neither is it granted by the state. However, in practice, individuals are not capable of complying with the rigorous procedural requirements of Jewish divorce law. And the Beth Din, which is the court of Jewish law, which obviously see is very active in the United Kingdom, a number of Beth Dins are very active in the United Kingdom, in, among other things, supervising these divorce proceedings, they will always play a significant role. And ultimately, it's the Beth Din's document which testifies that the couple have gone through the relevant procedures, which ultimately enables a woman to remarry. So therefore, at this point, I really want to make clear, it cannot be stressed enough that any solutions where we try to ensure that people who deserve a divorce will get one, their effectiveness depends on whether a Beth Din will view a subsequent get as acceptable and essentially issue the woman both supervise her get and issue her a document which says that she can remarry, which she can then use in any other Beth Din in the future to be allowed to remarry. Now, this structure of Jewish law requiring consent for divorce, where divorce cannot simply be granted by any kind of state power unilaterally on grounds. We need the husband to actually give it, leads to what has become known as the Agunah problem. And this Agunah literally means chained woman, and this literally means the situation where a woman is quite aptly chained to her husband because she cannot receive a get and she is in a situation where she cannot remarry. Now, in the Talmud, where the term Agunah was originally used, that was generally used about husbands who perhaps went missing. It wasn't sure whether they had died. But today, the modern Agunah problem specifically refers to husbands who we know where they are, they haven't disappeared, we're not sure if they've died, but they are recalcitrant. They refuse to give a get to their wives. Often this is based on financial disputes, and they are using it as leverage for financial disputes. In some cases, unfortunately, it can be entirely malicious. Now, it's important to note that although Jewish law marriage has long been recognized by law as also constituting marriage in English law, Jewish divorce is not recognized in this way. So we have a situation of conflict where a couple may be divorced in Jewish law, but not in English law, or vice versa. So even if a couple receive a civil divorce, they won't necessarily be divorced in Jewish law. And even if a couple is divorced in Jewish law, they're not necessarily divorced in civil law. The two are entirely distinct. I mean, an interesting fact I recently became aware of, and might be interesting for the family law history nerds in the audience, is that when the bill, which eventually became the Matrimonial Causes Act 1857, was first presented by the government in Parliament, and that culminated in the transfer of divorce from the ecclesiastical to the secular court, the government's first version of the bill actually proposed that divorce of marriages created under Jewish law would be under the jurisdiction of the Beth Din, the Jewish courts. And to some extent, we might have been in a better position now because the problems would have been more acute. We might have had state power backing up those courts, etc. We might have ended up with a very interesting two-track system similar to Israel. But this amendment was rejected. The Lords weren't having any of it, and ultimately civil divorce became the norm even for those who were married by Jewish law. And that paves the way for this two-track system we find ourselves today. Now, despite the mutual consent requirement, women are disproportionately affected by this problem for two reasons. First, in some situations, a husband may be able to avail himself of a special, albeit onerous procedure. It's called the heter mer rabbanim, and this allows him to remarry without a get. Oh, and that's not available to a woman whose husband doesn't give her a get. Moreover, the consequences of a woman remarrying without a get are considerably more severe. So any resulting children of a woman, but not of a man, will have the halachic status of a mamzer. So in Jewish law, that means a child of an adulterous or incestuous union, and that child is then forbidden from marrying within the Orthodox Jewish community. I would stress that all the problems I'm discussing are specific to Orthodox Judaism. Other denominations, more liberal denominations, have created workarounds to many of these problems, but Orthodox Judaism, be it as being based on absolute acceptance of both the written law, the biblical law, and the oral tradition, doesn't have the option of coming up with workarounds which weren't accepted by the halachic, the Jewish legal authorities of previous generations. So, I mean, that is not to say that there isn't problem on both genders. The Federation, Beth Din, for example, has recently stated that the get refusal cases it deals with are more or less equally split among the genders, but because of the fact that it's a lot more severe for a woman, so the gendered nature of the Agunah discussion reflects that, and that's why I will use gendered language throughout this talk. Now, so what can be done in a situation where a husband refuses to grant a get to his wife? Now, before we look at state intervention, I want to look at Beth Din enforcement. So what can a Beth Din do, and what have Beth Dins done before the state moved into this area at all? And in all of these cases of coercion, I want to just describe what happens, but then get back to it and then ask the question, how is it acceptable if there is a requirement for consent in Jewish law and duress is not valid? So start off with Beth Din enforcement. Over here on the slide, you should see I've just put in two pictures of some high profile get refuser cases. And what these signs are signed by the London Beth Din. The Sephardi Beth Din has co-signed one of them. And what they really are doing is applying powers which the Beth Din have within the law, powers of social ostracization, which means they are calling on synagogues not to allow the relevant get refuser into the synagogue, and they are inviting people to consider whether it's appropriate for some to have contact with the person as long as they don't give a get. So while obviously there is no state power, and as we shall see, certain forms of physical coercion will also be problematic, what a Beth Din can do, and this is very clear in the Code of Jewish Law, it can enforce an order of social ostracization. And this is what we see in these notices which happened before the specific instances of state intervention, which we will now consider. So the first instance of state intervention in this jurisdiction occurred with the Divorced Religious Marriages Act 2002. And this amended the Matrimonial Causes Act 1973. And it provides that if a husband is refusing a divorce, if any spouse is refusing a religious divorce, then they will be denied a decree absolute by a court. The court has jurisdiction to deny a decree absolute until they have taken such steps as are required to dissolve the marriage. So that was the first step. I mean, ultimately the problem with this step is that it's not necessarily the most effective, because often in the most intractable cases, the husband is willing to go off and live his life without obtaining a civil divorce. Unless he needs a civil divorce for a specific legal reason, this often will not be enough to actually make the husband give a get. So fast forward from Divorce Religious Marriages Act 2002, I would say the next most significant intervention, before we discuss recent legislation which has been in the headlines, and to some extent, some of the developments, this area is moving so fast that some of it happened after I published an article a few months ago, is the case of More and More. So this is a case in the Court of Appeal. And what happened in this case was that a husband, I mean, most of the case involves financial non-disclosure of assets, but what I want to zero in on is one of the things a trial judge did was impose a financial order on the husband. And it said one of the things the husband is doing wrong here is that he is not giving a get. And therefore, the court imposed a penalty on the husband. It imposed regular payments on the husband, which are due payable to his wife, until such time as a get is granted. And this order was upheld by a unanimous Court of Appeal. And as we can see in the quote, the court made clear that it viewed the consequences of a husband not giving a get as a sufficient reason to grant financial relief under its discretion or under Section 25 of the MCA 1973. So that was one significant intervention, and that's using financial orders to make a husband give a get. And we'll come back to this case shortly, because what's very interesting about this case is that counsel for the husband actually made a submission to the court saying that this financial order will be counterproductive, because the effect of this financial order will mean that the woman will actually not be able to receive a get at all, because the get will be deemed by a Beth Din as coerced. That was the submission, and we shall see how the court responded to that shortly. But I just want to trace first the developments of other state interventions. So moving to criminal prosecutions. So the background to this is in 2015, Parliament passed the Serious Crime Act. Section 76 of the Serious Crime Act 2015 provides that controlling and coercive behaviour can be a criminal offence within an intimate family relationship. Now, the idea, this is not CPS practice, this was an idea hatched by some lawyers, was that a private prosecution could be brought against a husband who doesn't give a get under this act, because not giving a get and thereby not allowing a wife to turn to a new chapter and remarry is itself a form of controlling coercive behavior. So a private prosecution was brought. Now, we don't actually know whether the private prosecution would have been successful, because proceedings in cases so far either haven't reached that point, or the case was settled in the interim. So we don't know if a court would have accepted the argument, but that was the attempt that was taken forward under Section 76. Now, when we fast forward to the Domestic Abuse Act 2021, recently passed, and here, Section 68 of that act provides that, essentially extends the scope of family relationships, because the problem of Section 76 of the Serious Crime Act was that it seemed that it would not catch a husband and wife who are no longer living together, regardless of whether they were married or there had been a civil divorce. If they were no longer living together, then the offence would not be applicable. And the key issue facing wives who are victims of get refusal is that those wives are often not living together. That's a problem. They're living entirely separate lives, and they merely just don't have a get, which allows them to remarry. These are not often cases we don't often have cases of get refusal where husband and wife are still living together, and therefore the likelihood of the prosecution succeeding seemed unlikely. So these are the changes that have been brought in to be clear, these are only prospective changes, so they're not currently active. And in the draft statutory guidance to the Act, the government accepted suggestions put forward by peers, and that was to make it clear that spiritual abuse is a case of controlling coercive behaviour, and a form of spiritual abuse may include the withholding of a religious divorce. And in Judaism, this concerns the get. So the government was making clear that in its view, withholding a get is controlling or coercive behaviour. Now, I'm personally still not convinced, even though now the husband and wife will no longer need to be living together, I'm not convinced, A, that a court will accept that controlling a coercive behaviour, which the statute makes clear needs to be repeated or continuous behaviour, whether simply withholding a document allowing a woman to remarry would be accepted by the court to be repeated or continuous behaviour, seeing as ultimately it's a mere omission. Obviously it's an omission with very severe consequences, but I'm not convinced that a court would accept that. The other thing we need to see whether a court will accept or not is whether the harm element is satisfied. So in the offence, besides for the need for repeated or continuous controlling coercive behaviour and the requirement for personal connection, the behaviour has to have a serious effect on the victim. And that's defined as causing the victim to fear violence or serious alarm or distress, which has substantial adverse effect on the victim's usual day-to-day activities. And this statutory terminology is borrowed from the stalking offence in the Protection from Harassment Act. So while there's no doubting the upset caused when a husband leaves his wife in this state of limping marriage, it's not quite the same as a woman under direct physical control of her abuser or stalking. And therefore, I'm not convinced that that prosecutions will ultimately succeed, but the jury is very much out, and we shall see what happens as these cases make their way through the courts. So now the key question here is, how do we square all the above interventions with the Jewish law of consent and duress? Now, obviously, when we're discussing the criminal law, it's very possible that the purpose of these provisions will not be to allow women to receive a get, but essentially punitive, as criminal law always is. It will punish the husband's previous behavior, and therefore it's irrelevant whether the woman ultimately will or can receive a get. The key question will be, will the husband's past behavior of not giving a get be dealt with? So it's not so relevant to discuss the consequences of whether a get will be able to be granted, seeing as that isn't necessarily the function of the criminal law. Additionally, since by definition criminal law is always punitive, so it's looking back at past behavior, the resulting get would, strictly speaking, be valid, looking at that narrowly, because whether the husband gives a get or not won't erode his past behavior. But what is problematic, what might be problematic, is if prosecutions are used as a tactic. So lawyers threaten prosecution by threaten a husband saying, if you do not give a get, you will be prosecuted, and thereby extract a get. And then they drop, obviously, the nature of the bargain is that if the husband does give a get, then the prosecution will be dropped. So then we are in a situation where the get is a direct result of coercion, in the sense that the husband is only giving it to escape prosecution. So how do we square all of this with the consent and duress requirements in Jewish law? So in more and more, we have a quote from Lord Justice Moylan, which I'm not going to read out. You can see for yourself on the slides. So Lord Justice Moylan made a comparison, an analogy with the Divorced Religious Marriages Act 2002. And he said, in the Divorced Religious Marriages Act 2002, Parliament said that you can only receive a civil divorce if a get is granted. Now, why isn't that a form of compulsion? Parliament clearly did not believe that was a form of compulsion, because the entire provision would have been nugatory if the subsequent get was invalid. So he said, a husband is not being compelled or required to obtain a get. The court is simply providing that unless and until he grants a get, he cannot obtain a civil divorce. The husband still has a choice. And therefore, in the same way, in the case of more and more, which involved financial payments, the husband had the choice to simply pay up and not give a get. And until he grants a get, he has to pay periodical payments to his wife. The court is not saying he has to give a get. The court is just simply speaking, providing the husband with a consequence if he does not. And that was Lord Justice Moylan's analysis there. Now, for me, that, as I wrote in the article, that analysis is highly problematic. Why? Because we are not discussing a jurisdictional issue. The key question here, in the case of more and more, for example, is not what Parliament intended or whether the court has jurisdiction to make an order. The key question is whether the court should exercise its discretion to make this payment for the purposes that the court wants it to achieve. And the purpose that the court wants to achieve is for the wife to be able to remarry. Now, for the wife to be able to remarry, she has to receive a get which is valid. And as we said at the beginning, its validity will ultimately be determined by the Jewish court, the Beth Din. So it's irrelevant when we're trying to work out what is consent and what isn't, or what is duress and what isn't. It's irrelevant to look at what Parliament intended. Rather, we have to consider what the situation is in Jewish law, and more precisely, what the view of a Beth Din is. Now, to be clear, Jewish law is a decentralized system, so we can't go to any specific Supreme Court like the Sanhedrin of Jewish law 2,000 years ago and just find out what the correct rules are. It requires intimate knowledge of Beth Din procedure, Beth Din practice, and which is why my ultimate argument is that when the courts want to do anything, or the legislation want to do anything helpful here, they have to have a discussion, collaborate with the Beth Din, find out what will be deemed to be acceptable, and then intervene. Provide the state power, but they can only do so if the effects of what they are doing will actually mean that the woman receives permission to remarry, rather than the Beth Din turning around and saying, actually, the get that is being given here is only a result of that pressure and therefore is invalid. So what is the position under Jewish law? Now, it is actually true that the Divorced Religious Marriages Act 2002 actually enjoyed substantial approval from the Jewish legal establishment, as was made clear in the Lord's debates at the time. It had the approval of the chief rabbis, of the court of the chief rabbi, of Dayan Ehrentreu was the head of the court of the chief rabbi, etc. So enjoyed approval and consensus from the halachic, the Jewish legal establishment. Now, why is that? Now, the key distinction to bear in mind here is that Jewish law distinguishes between the imposition of a sanction and the removal of a benefit. What does that mean? Consent resulting from intervention interfering with a party's physical, economic liberties is not freely given. That's considered a product of external pressure. Where a party is denied something that they have no inherent right to, then they are merely being denied a benefit, or rather being offered a benefit subject to the fulfillment of a condition, which is then deemed to be an incentive. So in any case of when we're trying to work out, is something coercion or not, we have to work out, is this an interest or a right which the husband enjoys? Is that a right which is protected under Jewish law? If it is, then interference with it, or the threat of interference with it, will constitute duress. If it is not, then it will be fine. And this distinction ultimately which is really the distinction between a threat and an offer, is a familiar one in English law. It's referred to extensively in academic literature in the contract, in the context of vitiation of consent for the sexual offences. It's a clear distinction which will always have to be employed in any system applying duress. So now, when we view the 2002 Act, no one has a right in Jewish law to have a civil divorce. It's the state's prerogative, and the state grants you a divorce. And therefore, Jewish law is entirely okay with the state saying, you can receive a civil divorce, but you can only receive a civil divorce if you grant a get. You're not being forced to do anything. You're simply being granted a benefit, and that benefit is being made conditional on you behaving in a certain way. That also explains the Beth Din's enforcement, social ostracization. No one has a right for other people to talk to them. No one has a right to enter into synagogues. Ultimately, it's the synagogue's right to determine whether someone can enter or not. And therefore, seeing as a person doesn't have a Jewish private law rights for all these things, they can be withdrawn and then offered back to the husband, conditional on him behaving in a certain way. The problem in Moore was that this was now extended to financial sanctions, and a person clearly has a private law right to that asset. So this now became an interference with financial assets, which the general consensus is that economic duress is duress in Jewish law. And therefore we end up with a problem where an order which actually had the potential of invalidating a get has now been made based on an analogy to the 2002 Act, which was based on an analogy on parliamentary intention. And as I've argued, the key issue wasn't really parliamentary intention. The key issue was, how would the Beth Din and Jewish law deal with it? And Beth Din and Jewish law would make a very clear distinction between the 2002 Act and financial sanctions. And the same, as you might imagine, might apply to the threat of imprisonment, which certainly crosses that boundary and is an interference with the right in Jewish law. So I've set some elements of duress in Jewish law out on the slide. These are a summary of the relevant principles which are found in the Code of Jewish Law in Agunah Ezer, chapter 134. I don't have the time to elaborate on all of them now, but one key thing that I will pick out from those elements is that the key thing to look at when we deem whether a threat is lawful is whether it's lawful under Jewish law. So Jewish law doesn't recognize, if, say, the state passes a law and therefore the state is allowed to coerce an individual, the Talmud makes it very clear that it won't view the fact that the state outlaws something or forces someone to give a get as lawful and therefore not duress. A lawful threat does stop something being duress, but it has to be a lawful threat under Jewish law, not under English law. And therefore, legislating our way out of this issue is not an option. So, seeing as time is short, and I do want to be able to field some questions from the audience, I'm just going to run very briefly onto how collaboration with the Beth Din would improve things. So there's been a lot of technical English law, Jewish law. So here, just for interest or amusement, is a 1926 page of the Illustrated London News, not Jewish News, the London paper. And this is actually a feature on the Beth Din as it operated at the time, 1926. And as you can see, the central picture is actually a Jewish divorce case in action in 1926. So this is the issue over here that we're discussing is both an issue and context, which goes back quite a while in this jurisdiction. So collaboration with the Beth Din. So we ultimately, the key takeaway here is that the courts or Parliament cannot simply legislate or come up with orders themselves without running the risk that that will undermine the woman's interests by, instead of providing an incentive for the husband to give a get, which it will do, it will simply make the Beth Din say that that get will be invalid. So how can we get around that? So essentially the one answer is to collaborate with the Beth Din, but how will that help? How will that get around the fundamental issues, which are consent and duress? So once you collaborate with the relevant Beth Din and you find out the effect of the orders which a court or the effect of a statute that Parliament are contemplating bringing in, there actually are a lot of avenues that we can use to attack the problem. For a start, Jewish law in certain circumstances, not in all circumstances, but in some circumstances, according to some authorities, for example, cases of physical abuse, does allow coercion, and because that coercion is lawful under Jewish law, it's not considered to be duress. Now, if the Beth Din issues a ruling saying that in this situation, coercion can be applied, then that stops that coercion being deemed to be duress. And then it can use the state power of the courts in order to enforce that. So that's one key way how collaborating with the Beth Din can actually solve the issue in some cases. Another way is finding out which financial sanctions a Beth Din would impose, for example, for maintenance, and then imposing those same financial sanctions via the state power of the courts, which again, seeing as the Beth Din themselves would have done that, that would be viewed to be entirely fine. Another thing we can look at is forcing the husband to engage with the Beth Din process. And this might be better used by a civil order, so non-molestation order or domestic abuse protection order under the new act, which rather than seeking to criminalize the not giving of a get per se, at least make the husband go to Beth Din, attend sessions where you're not coercing the get itself, but that at least increases the chances that the husband will cooperate, although admittedly, it's certainly not a solution in itself. None of these things are comprehensive solutions. It's a toolkit of various solutions which we can look at and might work in individual cases. If we use that idea, if we use the idea of civil orders and we take it further, another thing which obviously would require some innovation and some political will to get around, because it would be highly unusual. One thing that Jewish law allows is travel limits. So for example, if a court were to say to order that a husband would not be allowed to leave the country until he gave a get, that would not be considered coercion under Jewish law. It's simply, again, withdrawing the right to travel, which the state can do. And finally, a civil order, though, to give a get, though it couldn't be backed up by threats of imprisonment or fines, because that would, again, interfere with the husband's rights, what could be done is, in cases where this is relevant, using the ancient remedy of sequestration, which essentially enforces contempt of court by saying that the court can withhold financial assets until a husband cooperates with the court. What can be done is we can sequestrate public payments, so welfare payments, pension payments, things like that, which are not taking the husband's money away from. That again, a Beth Din would probably inform the court that that would be okay. That would be a legitimate form of coercion under Jewish law, and that could be applied. So as long as we do this cleverly and in collaboration with the Beth Din, finding out the circumstances of each individual case and what that warrants, we could actually find solutions, if not to all cases, to at least a great number of them, simply by finding out what the effects in Jewish law of any order would be, finding out in advance from the Beth Din what the effects would be, and then tailor-making any specific order to make sure that we ultimately get to what we all want, which is allowing the victim of this abusive behavior to remarry. So I'm going to stop there and I shall field some questions.
Okay, thank you very much. That was really fascinating. And thank you all for coming as well. We've had over 50 people, and I think it just shows how important this topic is. So moving to the questions, we've had a point of information from Gary, who's said that he's in the course of prosecuting one of the cases. And then we've got 2 written questions currently. In fact,
so I'm looking at the written questions. I'm going to reply to Martin's first. And thank you, Gary, for mentioning the case of Abayu Dayan. That's certainly a very, very long and intractable case. And I did read in the papers that this is proceeding to trial, and it'll be very interesting and probably set a precedent to see how that case goes. Replying to Martin, so Martin raises the issue of coercion via the family court, and whether if a family court says that if someone's withholding a get, they're abusive, and therefore denies access to children if a husband doesn't give a get, would that be coercive? So the straight answer is that might be a situation which the best thing would actually be okay with, because the relevant family law, ultimately the best interest test will be applied. So when the family court are deciding who children should be with, they're not entitled to punish a husband for not giving a get or to make an order for the purposes of the wife. The only thing they can do is look at the interests of the children. They will only use get refusal as an indicator of the husband's behavior. So if the husband is someone who treats his wife in that way, perhaps he shouldn't be someone who should be able to look after the children, and abuse is being looked at more and more by the family courts in this regard. So a Beth Din might not view that as coercive at all, because it's not an order which directly relates to custody. It's simply something being used as evidence in a custody decision. So I have a question here from Ruth Deach, so that's Baroness Deach, and I'm just going to read it. So why doesn't Dina de Malkuta Dina apply? Obedience to civil law of the country where Jews live is an obligation. Now, okay, so there are 2 questions here. I'm going to deal with them in turn. So the problem here is that the Talmud specifically says, although it's true that Jews are required by the Talmud to obey the laws of countries wherever they are, the problem here is that no one is saying that the husband does not have to give a get. The rabbinic authorities are also telling the husband that they have to give a get. The problem here is that even where husband does have to give a get, the rabbis only instituted the rule that you can actually use physical pressure or economic pressure in very limited circumstances. They didn't confine it. They didn't say that you can do so in every case where husband is obligated to give a get, even obligated under Jewish law. So therefore, there is a limited set of circumstances. Due to the decentralized nature of Jewish law, no rabbis today can actually add to that list. And certainly state authorities outside the system, while their laws obviously have to be respected, can't add to that list as well. And so there is an issue here where, regardless of whether the husband has to actually divorce his wife and should be called out for not doing so, that doesn't mean that he can be coerced to the level where we can disregard his consent. Unfortunately, that's just the state of the law. I'm not evaluating the law, the Jewish law. I'm simply stating what it is and how it's applied. Now, the second argument made by Baroness Deach is, she says the coercion argument does not seem to have been used when women are forced to pay their husbands for the get. So this refers to a situation where a husband doesn't want to give a get, and a woman either relinquishes her rights under civil law or actually makes a payment to her husband in order to achieve a get. So why isn't, so Baroness Deach is arguing, Why isn't that coercive? And I agree, it is coercive, but let's think about what is coercive. What's coercive is the fact that the woman is being made to pay money. That's coercive. And perhaps that should lead to a claim of restitution, where the woman has been coerced to part with money unlawfully in order to get her get, and therefore maybe she should have a claim for her money in the relevant tribunal. But the get isn't coerced because the woman does want the get. That's exactly what she wants. So the argument can't be made in this case that the get is invalid, because what's being coerced isn't the get. What's being coerced is the payment made by the woman. So that wouldn't invalidate the get.
We have lots of other questions.
I have lots of other questions, so I'm just going to. I have one question which says, have you considered whether the state refusing to pay someone welfare benefits, which might be acceptable in Jewish law, might be compatible with convention rights and the Human Rights Act? I personally believe that there's no reason why it should not be compatible, because in the case, we're talking about a husband who is in contempt of court, who can be imprisoned, who's subject to fines. So if you can fine someone and that isn't against the Human Rights Act because you're doing it in response to contempt of court, I can't imagine why it would be more of an interference with the husband's rights to say, no, let's not fine him by taking money that he has, but rather withhold welfare payments to him, which he hasn't received yet. And there is precedent in English law, perhaps older cases, of sequestration working in that way, withdrawing pensions, withdrawing welfare benefits, which is just the flip side of, from English legal perspective, there's no difference between that and fining someone. But from a Jewish perspective, it would be valuable if, at least in some cases where we don't have an alternative, we limit ourselves to those cases. Now, there's a point here made by Ariel Toby Cohen, who I think it's actually raises a good point. So I think I should deal with it. So he says, are there perhaps examples from other countries where civil secular courts have become involved in measures such as those discussed by me today? So there are very many. I didn't deal with them simply because of time frame. I wanted to restrict myself to the UK. The important thing to say here is first that in Israel, the rabbinic courts are backed up by state power, and they can ensure that if a husband refuses to give a get, he faces sanctions. He could be imprisoned in some circumstances, or he could be made not to leave the country. But again, the important thing to understand is this. The important thing to understand is that there are two, as I mentioned, there are two types of obligations to give a get. There's an obligation to give a get where physical or economic coercion can't be used. And then in Israel, what they will do is limit themselves to withdrawing the person's driving license, withdrawing their passport to the extent that they can't travel outside the country. And then there's a higher level, which in Hebrew is called the coercion order, which allows physical coercion to be used and the husband to be imprisoned. And so therefore the state and the Beth Din in Israel work on that basis. The problem in this country is that we don't have that intermediate category where we can apply some methods when all the methods aren't available. And we also don't have the collaboration with the Beth Din yet to allow the coercion orders to threaten imprisonment when they apply. And therefore, those types of avenues which are explored in Israel don't necessarily apply here. So that's just one country, obvious country to talk about. Another thing which I'm not going to discuss now, but if you read my article, you can look at, is the state of New York. And in the state of New York, actually, it started off with legislation withdrawing a civil divorce if the husband didn't grant a get, just like in the UK. And then just like in the UK, it then moved, the legislation changed to actually say that financial equitable distribution of assets could be affected by not giving a get. And at that point, the New York law lost its rabbinic consensus supporting the decision, and whether or not a get now given in New York can be affected by that is a matter of great dispute. And in fact, the one more recent development is that the constitutionality of the law has been called into question, because a husband argued that it's against his First Amendment rights, it's against his freedom of religion to be coerced into fulfilling what he argued was essentially a religious obligation. So we have a comment here: the Israeli experience actually demonstrates the risks of state involvement. The Israeli Beth Din that has extensive power backed by the state actually avoids using its power out of fear of coerced get, I assume. So, okay, that's an interesting point there made there.
There's a question from Tracy Allen at the top.
Is there anything else that I haven't addressed? So I'm not sure how to. So Tracy says, why does it take a long time for the Beth Din to issue ostracization notices? It shouldn't take. The clear answer is it shouldn't take a long time. And if the situation is that protracted, then that should certainly be raised with the specific Beth Din responsible. She also makes a point that the collaboration points I make don't operate within a reasonable time frame. I'm not sure that's correct. So, for example, if you look at collaboration between the Beth Din and the courts in other matters. So, for example, there was a recent case in the High Court, Sterling and Rand, and that involved considering an arbitration done under Jewish law, a case which was decided under Jewish law. There were some issues with the arbitration, and the court sent it back to the Beth Din and asked the Beth Din to issue its ruling on a specific aspect of the case. And that was given, and then the decision was handed down, say, a few months later. So I'm not sure that the time frame has to be that long. Of course, if the time frame has been that long in specific cases, then that's an issue and should be raised with the Beth Din. And there's no reason under Jewish law why it should take that long. And in actual fact, I think my slides are still up. There's a picture there of Joanne Greenway, who has recently left the Beth Din, but was the London Beth Din, but was brought in as a get caseworker to work on these cases and try to expedite any process which could be done and look at it.
A question from Charlotte Kelly.
Right, so Charlotte asks, where a husband refuses to grant a get, but the wife is living separately, does the Beth Din become involved in ordering the husband to pay child maintenance? And is there a risk that subsequent get is obtained by duress? And if an order is made by CMS, does this have any effect? The answer is, an order by CMS would have no effect, because the order wouldn't be dependent on whether the husband gives a get or not, so that wouldn't be an issue. Does the Beth Din become involved? Well, the answer here simply is the Beth Din might be involved if the parties choose to go to the Beth Din, but the Beth Din's order will not be enforceable in a court, because the arbitration is not enforceable in family law matters. So they could arbitrate in the Beth Din, but that wouldn't actually be enforceable in court. Would that risk the subsequent get obtained by duress? No, unless the Beth Din made the order conditional on the husband giving a get, which it would be unlikely to do in that scenario. But if it did, then obviously it would only do so if it viewed that there were grounds for coercion. And therefore, in that case, if the Beth Din ultimately are okay with it, then the woman will be allowed to remarry. So there would be no issue there. Is there anyone else, perhaps? Oh, so Gary says, and this is, I think, an important point. So Gary says there's a precedent, and to be clear, Gary, as Gary said before, Gary is the lawyer who worked on these private prosecutions. So it's great that we have so many people here who are actually involved in this issue participating. So Gary says there's a precedent where the LBD gave a get in the face of criminal prosecution. So I dealt with this in my in the article, and the question here is that precedents have been brought. There's in fact a precedent quoted in Moore from 1969, a case called Brett and Brett, where financial order was made, and nevertheless the Beis Din did allow a get to be given afterwards. I want to be clear: there's no strict rule saying that if a threat is applied, then any get given afterwards is invalid. The key question is, just like in duress and any other system in English law, is the get only given because of duress? And would a reasonable person have succumbed to the threat? If I just move on my slide here, I've set some of the principles, and this was precisely for this point. So a Beis Din, it's always up to a Beis Din when a criminal prosecution, say, has been made, to say, regardless of the criminal prosecution, we don't think this was the decisive factor to give a get. So for example, there was one case reported in the Jewish Chronicle, which was the El-Kubi case, where the husband himself made the argument saying, the fact that I want to give the get, I've decided to give a get, has nothing to do with the prosecution. Now, whether we believe him or not, I'm not sure. But ultimately, the question for the Beis Din is whether to assess the case as the get being extracted as a result of coercion or not. But if the Beis Din tell the court in advance, say in this collaborative model, that in this case we believe that the only reason the husband is giving the get is because of this threat, and also we believe that there are not grounds for this threat, then we would have an issue where the get would be deemed to be invalid. So for example, if we mention the Abu Dayan case, which is one that Gary mentioned, it's possible, seeing the intractable nature of the case and so on, that might be a case where the Beis Din might rule that the coercion order is warranted, in which case the Beis Din is allowed to tell the court, listen, on our behalf, can you please enforce enforce our order saying the husband is to give a get under any form of coercion whatsoever, physical, economic, etc. So there's no blanket rule saying that once there is a threat to use state power, a threat for physical coercion, economic coercion, the subsequent get is invalid. It's a potential issue. Whether it's applicable in any given case revolves around all these factors that we're discussing, which is precisely why it's worth it to discuss it in advance with the authority who's actually going to supervise the get, to work out what its likely effects would be. So I have a question here from Ros Altman, so that's Baroness Altman. I'm just going to read it. Your argument seems to suggest that a woman can be forever trapped by a husband by the Beis Din's interpretation of Jewish law. If she has to resort to British court for protection of her religious rights, likely to happen once the Beis Din have shown they cannot achieve her freedom, and a husband then decides to grant the get, she may find the Dayanim decree she is now eternally changed. So how would Jewish law then be viewed? I see the issue. I want to emphasize again, I am not here trying to evaluate the system at all. That's not what I'm trying to do today. I'm simply trying to assess what would be the situation, what would be the likely effect of any given order, and whether it would actually be helpful in ensuring that the woman who that order is made for will be able to remarry within the Orthodox Jewish community. I mean, many people, I'm sure many or most modern people would find the entire system of the way this operates to be alien to their values. But the key issue here is that ultimately the women who are affected by this are women who are within the system. They practice the Orthodox Jewish faith, and they believe that they only want to remarry in a situation where they have received what is a kosher get. Simply receiving a piece of paper is not going to help them. They want to remarry in a situation where the Beth Din can say that they have received a valid get. So what we're trying to do here is not simply force the husband, as I say, to give her a piece of paper. We're trying to ensure that the woman receives a get, which is considered valid under Jewish law. And the assessment or evaluation of Jewish law and whether we like it or not, I think is irrelevant to the question of what is actually helpful. And then Baroness Alton adds, I find it difficult to imagine that any reasonable person would consistently and willfully keep refusing the get. And what is the Beth Din's view of the woman's perspective here? So I just want to reiterate that I think that's true. I think no reasonable person should withhold a get in a situation where the marriage has irretrievably broken down. And it's unreasonable behavior. And we should direct all our efforts to trying to ensure that the woman escapes that kind of abuse. But whether the husband is acting reasonably or unreasonably, unfortunately, within the system, isn't decisive. So a husband engaged in unreasonable behavior doesn't allow the Beth Din to simply say, we pronounce the woman divorced. The Beth Din still has to supervise a get, which meets the requirements of Jewish law. And just as one of the requirements of Jewish law is that the standard form should be written correctly, an element of the get is either consent or it fits within a box where we can bypass consent in certain circumstances, as I've said. And unfortunately, not every case of unreasonable behavior meets that threshold. So
I think perhaps if you want to pick one more question, because our attendee numbers are dropping off and it's gone past 2 o'clock, so we may have to draw things to a bit of a premature close. But
sure. So I'll just finish with those that have come up, and I'm not going to answer any more. So one question here is there not something embarrassing about a legal system A having to turn to legal system B to resolve its problems? Now, I think what I would respond to that is that personally, I believe that the issue here is that we have one legal system operating in a country where it has no power whatsoever. So it might pronounce orders, but it has absolutely no state power to enforce them. And therefore, it only makes sense in that scenario that when we have a woman who requires the assistance of a Beth Din order, but that the Beth Din can't enforce it in any way beyond social ostracization, it should go to the state to enforce it, because the alternative would be the Beth Din having its own enforcement powers, which I think is just not going to happen in a secular Western liberal democracy. And the alternative in the other way, which is we simply follow English law, is not going to work in our multicultural society where we have people within following Orthodox Judaism, which involves following Orthodox Jewish law. So inevitably, we're at a hybrid where the Beth Din issues its pronouncements on Jewish law, but has no power to enforce them and has to go to the state to enforce them. And what I disagree with the questioner is I think in Israel, there is a much more effective system, not wholly effective, but much more effective system, because state power and Beth Din power are aligned. And while we don't do what is discussed in the Talmud, which is beating the man until he gives a get, and we don't use physical coercion in that sense, we still do use imprisonment, and imprisonment is a form of coercion, which is both, in cases where it's warranted, highly effective. So I think that form of coercion is effective. And the problem over here is ultimately the mismatch between a system which is simply an authority and religious law to those who adhere to it, that has no state power, and the state having the monopoly of power to enforce it. And that is precisely why, in my opinion, if we bring those two together and we make sure that they work in a cooperative and collaborative way, we could, if not solve all cases, make far better progress than we can when they are working at loggerheads. I'm afraid it seems that that is all the time that we have. So thank you everyone for participating. I am very, very happy to field any more questions or discussions or criticism, of which I can see there's plenty, via email, so wg270@cam.ac.uk. And that some of the points I didn't have time to dwell too much on, but you can read more about them in the article in the recent CFLQ. So thank you everyone for participating, particularly those who are really contributing towards this discussion and trying to do good things on behalf of the victims in this saga. And I hope to hear more from you in the near future.
Okay, well, on behalf of both the Cambridge Socio-Legal Group and Cambridge Family Law, thank you very much, William, for your excellent presentation and the way in which you've engaged in answering lots of questions. Thank you also to those who did ask questions, and clearly there's a lot of discussion to engage in here. Once I click the end button, the seminar will end and we'll all be removed from the room. But as William has said, he's very happy to carry on engaging in discussion. So thank you very much to everyone once again. I should say that we hope that a recording will be available fairly soon of this event. So if there's something that you want to revisit, you will hopefully be able to do that. So again, thank you very much, everyone, and take care. Thank you. Goodbye.
Thank you.